Dear students, and today we are going to discuss the new agreement, that is the TRIMS agreement. So, trade related investment measures. What is this new agreement? So, you can see the name itself says trade related investment measures. So, investment is very important for every country, especially foreign direct investment, because without foreign direct investment no country can invest in more and more areas, mainly lack of resources. So, these investing countries always want a code of conduct. Investing countries are mostly developed countries. They want a code of conduct for investment, or basically they want protection for their investments in the host countries. So, this discussion is not specific to the Uruguay round of negotiations. From time immemorial period, so these discussions were going on, and there were some efforts were there to consolidate some of the provisions. So, in this class we will discuss about the historical perspective of investment agreements, historical perspective of how this agreement finalized, and so what are the old provisions, what are the efforts taken by the countries to come out with a code of conduct for investment. Then what was the GATT provisions, Tokyo round of provisions, Uruguay round provisions, and definitely the present agreement, WTO agreement on trade related investment measures agreement. So, I was talking about the every time the countries want protection of their investment in other countries, especially protection from nationalization, because many of the countries, especially after the 1950s, the decolonization has happened. Most of the countries nationalized many of the industries, many of the operations, financial institutions. For example, like India, the bank nationalization cases, bank nationalization was happened. Other industries nationalization was happened. This is happened in some cases without compensation, in some cases with compensation, but not adequate compensation. So, you can see that in the history 18th and 19th centuries, the Europe and US want, because they are the main investors, they want standards of protection for investment. So, they want something more than national treatment. So, and also the host countries were not permitted to expropriate foreign assets. Expropriation is nothing but nationalization. So, these countries want certain provisions against expropriation. So, the Latin American countries, the first challenge, the favorable treatment of foreign investors. So, you are the foreign investor, and the attitude is that you should give a red carpet to us and give a treatment which is more than a national treatment. So, it means different treatment to different investors. So, I am a foreigner coming to your country with my money. So, you give a special treatment over and above the national treatment. This was the recognized principle at that point of time. So, in 1868, see the Calvo, so you can see that the Argentinian minister who talked about these particular rights and prohibited countries from intervening to enforce the claims of their citizens in other countries. And Calvo doctrine clearly says that you should give primacy to the domestic law rather than to the foreign law, especially in arbitration proceedings. So, there is a lot of discussions in between the First World War and Second World War. So, the formation of League of Nations was one of the the forum for discussions on this particular topic. So, the history after Second World War is very different. So, and you can see that, but even the Second World War, the countries were not successful to establish an international regime for investment. So, actually they want to form a multilateral investment agreement. That was not happened even after the Second World War. So, in the Havana Charter in 1948, which formed the Bretton Woods institutions, which talked about foreign investment. So, there is a chapter on economic development which discussed about the treatment of foreign investment, but unfortunately this charter, Havana Charter, was never recognized, especially the US has not signed it and never ratified, and its provisions were become only commercial policies incorporated in the GATT, and it was never a part of the GATT agreement. And you can find that the same time the United Nations Conference on Trade and Development Employment, the United Nations Trade and Employment. So, they discussed it on expansion of international trade and expansion of investment measures, that part of the wide discussion of restrictive business practices. So, we talked about Havana Charter, which included provisions, these particular provisions were taken, never taken off. So, that is the charter of ITO was dead, the ITO was never came into force, but the negotiations based on it was going on in the different round of GATT negotiations, but none of the countries want to take the burden of commitments with regard to investment at that point of time. Then after the failure of ITO, you can see that the GATT has ruled from 1947 to 1994 December, a long period of time. So, but in this period also the discussions were very active, because investment promotion, every country do the investment promotion, and at the same time they want protection as well. So, investment promotion and protection treaties and agreements were signed in between bilaterally by many countries. Such treaties were intended to protect investors' property, especially protection from expropriation and paying compensation. So, the Hull formula, the Gordon Hull, who was the State Secretary of the United States, prescribed the Hull formula for the compensation. So, his formula was very simple, that is prompt, adequate settlement of procedures, settlement of disputes, prompt, adequate and effective compensation, prompt, adequate and effective compensation on non-discriminatory treatment, transfer funds and dispute settlement procedures. This was the Gordon Hull formula which was prescribed for any investment, and the number of business practices, restrictive business practices has increased even after 1947, and the GATT has discussed this. So, for example, international cartels, trust and other the cartels were formed, and these were hampering international the international trade expansion all over the world at that point of time. So, the studies were done. So, the most important is 1955 resolution on international investment for economic development. So, the parties has adopted this resolution. So, which clearly says the countries to conclude bilateral agreements to provide protection and security for foreign investment, because before 1955 the effort for forming a common single international agreement on investment was failed. So, now they urge the countries to go ahead with bilateral investment treaties, and now also its bilateral investment is BITs are very famous, and there are thousands of bilateral investment treaties are all over the world. So, here and also you can see other developments in between. In 1974, the United Nations General Assembly has passed the Charter of Economic Rights and Duties of States, and some of the provisions very clearly says right of every state to regulate and exercise authority over foreign investment in conformity with its national objectives. So, here you can see that the Hull formula was not adopted, but the Calvo clause which was adopted at this point of time. So, a draft code of conduct was formulated for transnational corporations, because these TNCs or MNCs, multinational corporations, become more and more involvement in the domestic politics and domestic aspects of the country where they were going. So, they come out with the code of conduct for transnational corporations, and also it is issued by the United Nations Center on Transnational Corporations, and you can see that these are the legally binding code of conduct, and also multilaterally agreed equitable principles and rules of control of the restrictive practices are also negotiated under the United Nations after 1945. This is under the United Nations Conference on Trade and Development. So, it covered the investment and competition policy as well. So, that also is mostly not adopted by many members. In 1995, which we saw that the adoption of GATT, the adoption of the particular agreement, development agreement in 1955, and the most important development is the case between United States and Canada, which is known as FIRA case. So, the Foreign Investment Review Act. So, here the Canada insisted that certain types of undertakings to be made by the foreign investors. So, as a condition for approval of investment projects in Canada, this is nothing but a local conduct. So, certain conditions to be signed or conditions to be obeyed by these particular multinational companies, those who are coming to the Canada for business. So, this particular restrictions were questioned. So, it is famously known as the FIRA case. It is questioned before the GATT dispute settlement system in 1984, and this complained certain business practices or restrictions from the part of Canada. So, this particular case very clearly says that purchase of certain materials from the domestic markets or domestic sources which constitute the local content requirement and export performance requirement. So, these all addition to the barriers. So, the panel in this particular case, the dispute settlement panel, held that this particular requirement of local content inconsistent with the national treatment provisions of Article 3(4) of the GATT agreement, but the export performance requirements were not inconsistent. This is the GATT told. So, the local content again were declared as inconsistent with the national treatment principles, and this case made a complete problem to the countries like the United States or Canada or the Europe at that point of time, many countries in the Europe at that point of time. So, they have to amend their domestic laws. So, again the Tokyo Round Court. So, you can see that the Tokyo Round of negotiations up to 1979, and again an attempts were made to consolidate a law to eliminate these local content export for performance requirements. So, the many developing countries, they continue to maintain the foreign direct investment was beyond the GATT's purview. This was the attitude of developing countries. They said that only goods to be included in the GATTs, not investments. So, and also you can see that US and some other countries. So, they said that this should be, there must be some kind of regime should be added to the GATT for the protection of their investments. So, again the FIRA case, the case between Canada and the US sorry, has again got an opportunity for discussing the issues in detail and bringing about certain controls or bringing about certain rules and regulations on foreign investment. But so I already stated that the panel, GATT panel, has very clearly said that the local content provisions were against the national treatment principles, but they have they rejected the claim of the US and with regard to Canada with regard to the foreign performance, the export performance criteria, and one is accepted that local content is against the GATT provisions and the other one is rejected. So, investment is a major concern of every country, those who invest in other countries. So, what will happen to their investment? So, Uruguay Round, you can see that there is a concerted effort by the developed countries, and I would say that including the developing countries and India actively participate in the drafting of these agreements. They want various disciplines to be included, and that is why you can see the elaboration of in the Uruguay Round over and above the goods, services were included, then investment were included, and the intellectual property were included. So, here you can see that some of the provisions, some of the laws passed by countries like United States, the Omnibus Trade Competitiveness Act. So, here it was happened during the Uruguay Round negotiation time. So, this talks about the foreign investment. So, transnational corporations. So, all the concerted efforts were be looked by the US as barriers. So, US said that these barriers should be removed. These barriers should be removed by the developing countries for the smooth working of their multinational companies. And you can see that the GATT provisions were expanded, expanded to develop investment regimes. So, the trade related investment measures should be prohibited. This was the concern of the developing countries at that point of time. So, US, for example, other Asian countries like the Japan favored all encompassing investment regime, a full investment regime as a part of the WTO, and limiting negotiations on investment measures with direct and significant adverse effect on trade. So, every country unanimously said that yes, what are the measures those who have direct adverse effect on trade should be prohibited. So, the TRIMS agreement, you can see that there is whole lot of discussions, and finally, they are agreed upon to come out with certain rules and regulations which is common to all developed and developing countries. So, and that is why you can find it in the GATT's agreement, positivist approach. So, the fourth mode of supply under the services is commercial presence, and mode 3. So, you can find trade in services, commercial presence. So, even though most developing countries are opposed bringing the trade in services under the purview of the GATT or the WTO at that point of time, but the developed countries were successful in bringing trade in services and include investment, and it is included as an acceptable terminology. For example, financial services, telecommunication services, all these were accepted terminologies under mode 3. And also here you can see that similar provisions, similar investment protection provisions were added to regional trade agreements, like the biggest regional trade agreements like NAFTA. Now it is RCEP, but at that point of time it was NAFTA. And this TRIMS agreement, so you can see that the non discrimination principle on investment is accepted by most of the agreements, and especially NAFTA prohibits number of performance requirements. So, the developing countries used to put performance requirements and differentiate. So, you can see that the NAFTA is a regional trade agreement. They want to include investment agreement provisions in there, and you can see that the lack of a multilateral treaty, which leads to 1330 bilateral investment treaties, which including 162 countries at that point of time, 1990s. So, bilateral investment treaties were flourishing even much before the Uruguay round of negotiations, before the establishment of WTO, but now up to 2022 it is reported that around more than 3000, around 3000, we can say that 3300 bilateral investment treaties are in place, and India alone party to 86 bilateral investment treaties. So, even though there is a multilateral treaty like TRIMS agreement is there, bilateral investment treaties are flourishing according to the convenience of individual member countries. And as we already talked about the Uruguay round of negotiations, but what are the issues faced by the member countries during the negotiating period? The major problem reported was lack of definition and clarity with regard to the investment measures. So, the developed countries took a broader view that the investment and investment measures should be added, and then developing countries took a narrower view and said that the technology transfer requirements should be taken into also consideration. And when it comes to the Uruguay round, again you can see that. So, there were strong disagreements among the developing countries with regard to the nature of commitments and also adding new disciplines. So, this was aggravated by the case between US and Canada, the FIRA case. So, this was also an important reason, and there is a close connectivity between investment and trade. So, the degrees are very clear, investment, trade are connected, and the countries want protection for investment, and also the countries didn't want to put barriers like local content, export performance and other performances, and the foreign exchange restrictions also used to be removed. Foreign exchange restrictions is also to be removed by member countries. So, we will come to the TRIMS agreement. Within the TRIMS agreement, whether any trade related investment measure is defined. So, you can see certain measures, trade related investment measures were provided as an illustrative list in annexure 1, but there is no specific definition of trade related investment measures. So, the governments usually impose restrictions or impose enterprise link the amount of imports to the level of its exports, export performance, so that every country wants the foreign exchange created must be in their country only, not transported not taken it back, not repatriated back to the host country. So, foreign exchange balancing requirements is one of the important criteria in the calculation of the TRIPS measures, and the value of export and import also is very requirement. So, within the TRIPS agreement, market access principles. So, for example, always you can put a foreign direct investment cap, ownership, equity restrictions, joint venture requirements and restrictions also can be put. If you look into the performance requirements, local content schemes are completely banned, export performance requirements are banned, foreign exchange balancing measures are also is not recognized by many countries. So, the performance requirements are also a problem. So, TRIPS agreement very clearly says, like any other WTO agreement, what is the objective? Progressive liberalization and also increase the economic growth of all trading partners, developing country members while ensuring free competition. So, that means the like any other WTO agreement, the TRIPS agreement provides for what is the objective of the TRIPS agreement. So, the legal framework of the agreement again says that there is subjected to the cardinal principle of WTO. One is the national treatment principles and another one is the quantitative restrictions under article 11 of GATT. So, they say that promoting liberalization and promoting investment and also at the same time the ensuring competitions. And so, the financial needs of the countries, investment measures, trade restrictive and distorting effects to be removed by every countries. And the coverage, you can see that the TRIPS agreement is not applicable to services. That is why you can see that trade related investment measures, only trade related investment measures are taken care by the agreement, but unfortunately, what is the trade related investment measures is not defined in the agreement, but the illustrative list we can find it in article 3(4) and article 11(1) of the GATT 1994 and article 3, which talks about the national treatment principles and which we already dealt many times about the national treatment principle, which is applicable to the TRIPS agreement as well. Article 11, which talks about prohibition of quantitative restrictions and imports and exports. So, quantitative restrictions are now banned under the WTO agreement. And if we come to the foreign investment, definitely you can put a cap, but you cannot prohibit foreign direct investment, but certain areas you can put restrictions subject to the national treatment principle. And local content requirement is absolutely not acceptable to any countries. And what are the list of trade related investment measures, that also we have to look into. So, you can see there are many trade related investment measures. We talked about the local content, quantitative restrictions and other trade balancing measures. So, if you look into elaborately, you can see an illustrative list of TRIPS in the annexure. For example, the local content requirement, which we already talked about it, local content, the FIRA case, trade balancing requirement, the balancing of the value of imports and exports, foreign exchange balancing, foreign exchange made available to the imports must be a certain proportion of the value of the foreign exchange realized from exports. So, foreign exchange resistance is also a problem. Then manufacturing requirements, certain products to be made locally, manufacturing limitations, it is preventing the firms from manufacturing certain products or product lines in the host country. Then again technology transfer, this is most important controversial provisions, that is the technology transfer. and technology transfer required specifically the technology to be transferred to the local collaborator or to certain types of collaborations to be entered into the host country and the investing country. Then it is not only technology transfer, licensing of technology, which requires the investors to license technology for use in the host country. For example, China has implemented this particular provision, and very recently the WTO dispute settlement system said that these provisions come under the trade related investment measures, and that is to be eliminated from the domestic laws. And other illustrative lists are domestic sales, export performance, export controls, and remittance restrictions, repatriation restrictions. Then local equity. So, here equity must be held by locals or local investors in the host country. Restrictions, that is local equity restrictions. Market reserve policy. For example, in every country the small scale industries have market reserves, market reservation, and that local production, which increases the local production. So, the basic commitments of GATT says that any kind of trade investment measures which is against article 3 or article 11 is under 2(1), which says that inconsistent with the provisions are against the TRIPS mandate, against the TRIPS agreement, against the TRIPS investment agreement. So, paragraph 4 of article 3 and paragraph 1 of article 11, which talks about the illustrative list of annexure 2 of the TRIPS agreement. And obligations, which you can see that substantial obligations. So, the members to notify every investment measures that are inconsistent with the GATTs. So, second, members must eliminate any TRIPS that is inconsistent with article 3 and 11 on a schedule and also on a schedule of 2 years from the entry into effect. And we can see again that the TRIPS may amend from time to time, the TRIPS list may be amended from time to time. And obligations, which we saw that there is a special provision with regard to the obligations of special and differential treatment, special and differential treatment to developing countries, but none of the countries give the special treatment under this particular provision, and the developing countries are finding it very difficult to get a special treatment. And also the TRIPS agreement established a WTO committee on trade related investment measures taking care of the functioning of the particular agreement. So, TRIPS inconsistent with national treatment principles. So, here illustrative list, all the illustrative list under local content are against exports or against they are selling in other countries. So, these provisions, any provision which is be inconsistent with article 3, the national treatment provisions are held inconsistent with the TRIPS agreement. So, illustrative list, long illustrative list which covers most of the areas, the volume, value, local production, export, import, etc. And also which you can see that, so value of products, that is also very important, or value of its local production is also important. And general exceptions exclusively deal with article 3 also. So, all the exceptions must be related to or appropriate to or under the provisions of the TRIPS agreement. And balance of payment problems, definitely the members can put a restriction on any agreement. Article 6 provides for the notification of the WTO Secretariat of list of obligations, in which TRIPS may be found. Article 7, which talks about TRIPS agreement, establishes the committee on trade related investment measures as a forum to examine the implementation of the agreement. So, there is a committee on trade related investment measures which is looked into. transparency provision. The transparency provision is applicable to all WTO agreements, are applicable to TRIPS agreement as well. So, all the laws and regulations to be published from time to time. So, I would say that the TRIPS agreement in when the beginning of the 20th century or 19th century is different from the present scenario, because in the present scenario the WTO agreement on investment is applicable to 164 member countries. They cannot come up with a new provision with a new TRIPS. This can be only defined as TRIPS, but I can explain to you. If you adopt any local content provisions, if you adopt any kind of illustrative list, any one measure from the illustrative list, then it is considered to be against the TRIPS agreement. So, the TRIPS agreement deals with only trade related investment measures, which is mentioned under the this particular list. So, otherwise there is no rights at all. So, most importantly, we can see that the Uruguay round of negotiations has agreed at that point of time, had agreed only upon trade related investment measures, and it is considered to be against article 3 and 11 of the GATT agreement. So, no countries can put local content requirements, no countries can violate article 3 of the GATT agreement, and which will be considered as null and void by the countries, or you can go to the dispute settlement system. So, we will continue with the discussion on the TRIPS agreement, trade related investment measures, and some of the cases dealt by the WTO in the coming classes. Thank you.